A trust protects your wealth from taxes, lawsuits, and probate. Here's how to set one up. Most people think trusts are only for the ultra-wealthy. But the truth is, anyone building assets needs a trust to protect what they've worked for and ensure it passes to the right people at the right time. Without a trust, your family faces probate, estate taxes, and potential legal battles. Today, I'm breaking down what a trust is, why you need one, the different types of trusts, and exactly how to set one up to protect your family's wealth for generations. What is a trust? A trust is a legal arrangement where you transfer ownership of your assets to a trust entity, which is managed by a trustee for the benefit of your beneficiaries. Here's how it works in simple terms. You create a trust and transfer assets into it: real estate, bank accounts, investment accounts, business interests. While you're alive, you can be your own trustee, which means you still control everything. When you die, a successor trustee you've chosen takes over and distributes the assets according to your instructions. The key difference between a trust and a will: a trust avoids probate. Probate is the court process of validating a will, settling debts, and distributing assets. It's slow, expensive, and public. A trust bypasses all of that. Why you need a trust. Reason 1. Avoid probate. Probate can take months or even years. During that time, your assets are frozen. Your family can't access them. They're paying legal fees, court costs, and dealing with bureaucracy while grieving. A trust skips probate entirely. When you die, your successor trustee distributes assets immediately according to your instructions. No court, no delays, no public record. Reason 2. Maintain privacy. Wills become public record during probate. Anyone can see what you owned and who you left it to. A trust is private. Your assets, your beneficiaries, and your instructions stay confidential. Reason 3. Control how and when assets are distributed. With a will, your beneficiaries get everything at once, regardless of their age or maturity. A trust lets you set conditions. You can specify that your kids receive funds at certain ages: 25, 30, 35. You can release money for specific purposes: education, home purchase, starting a business. You can protect a spendthrift child by distributing assets gradually instead of in one lump sum. Reason 4. Protect assets from creditors and lawsuits. Certain types of trusts shield assets from creditors, lawsuits, and bankruptcy. If you're in a high-risk profession or you're building significant wealth, asset protection becomes critical. Reason 5. Reduce estate taxes. For larger estates, trusts can minimize or eliminate estate taxes, which means more wealth passes to your heirs and less goes to the government. If you're serious about protecting and transferring wealth, read the only living trusts book you'll ever need. It walks you through the entire process step by step. Links in the description. Types of trusts: there are two main categories: revocable and irrevocable. Revocable living trust: this is the most common trust for families building wealth. It's called revocable because you can change it, update it, or dissolve it at any time while you're alive. How it works: you create the trust and transfer assets into it. You act as the trustee, which means you control everything. You name a successor trustee who takes over when you die or become incapacitated. You specify how assets are distributed to your beneficiaries. Benefits: avoids probate, maintains privacy, allows you to control distribution timing and conditions, protects your family if you become incapacitated. Your successor trustee manages assets without court. Intervention limitations: does not provide asset protection from creditors or lawsuits. While you're alive, does not reduce estate taxes. A revocable living trust is the foundation of most estate plans. It's flexible, private, and ensures your wishes are followed. Irrevocable trust: an irrevocable trust is permanent. Once you create it and transfer assets, you can't change or dissolve it. You give up control, but you gain significant legal and tax benefits. How it works: you create the trust and transfer assets into it. A trustee, not you, manages the assets. The trust owns the assets, not you, which removes them from your taxable estate. Benefits: protects assets from creditors, lawsuits, and bankruptcy. Reduces or eliminates estate taxes. Medicaid planning: protects assets if you need long-term care. Limitations: you lose control of the assets, cannot be changed or revoked. Irrevocable trusts are used for asset protection and tax planning. They're more complex and typically used by people with significant wealth or specific protection needs. How to set up a trust. Step 1. Decide which type of trust you need. For most families, a revocable living trust is the right choice. It gives you control, avoids probate, and protects your family. If you need asset protection or tax planning, consult an estate planning attorney about irrevocable options. Step 2. Choose your trustee and successor trustee. While you're alive, you'll likely be your own trustee, but you need to name a successor trustee, someone who will manage and distribute your assets when you die or if you become incapacitated. Choose someone trustworthy, financially responsible, and capable of handling the responsibility. This could be a spouse, adult child, sibling, or a professional trustee like a bank or trust company. Step 3. List your assets. Make a comprehensive list of everything you own: real estate, bank accounts, investment accounts, retirement accounts, life insurance policies, business interests, valuable personal property. Not all assets go into a trust. Retirement accounts like 401ks and IRAs have their own beneficiary designations and shouldn't be transferred into a trust. Life insurance also passes via beneficiary designation, but real estate, bank accounts, and taxable investment accounts should be transferred into the trust. Step 4. Work with an estate planning attorney. Do not use online templates for a trust. Estate planning is complex, and mistakes can cost your family thousands of dollars. Hire an attorney who specializes in estate planning and trusts. They'll draft the trust document, ensure it complies with your state's laws, and help you transfer assets into the trust. Cost typically ranges from $1,000 to $3,000 depending on complexity and location. It's worth every penny. Step 5. Fund the trust. Creating the trust is only half the work. You have to transfer assets into it, a process called funding the trust. For real estate, you'll need to change the deed to transfer ownership from your name to the trust. For bank accounts and investment accounts, you'll contact the financial institution and retitle the accounts in the name of the trust. This step is critical. If you don't fund the trust, it's useless. Your assets will still go through probate. Step 6. Update beneficiaries. Make sure your retirement accounts and life insurance policies have updated beneficiaries. These don't go into the trust, but they need to align with your estate plan. Also create a pour-over will. This is a backup will that catches any assets you forgot to transfer into the trust. It directs those assets into the trust after your death. Common trust mistakes to avoid. Mistake 1. Creating a trust but not funding it. This is the #1 mistake. People pay an attorney to create a trust, then never transfer assets into it. The trust sits empty, and when they die, everything goes through probate anyway. Fund your trust, transfer assets, follow through. Mistake 2. Not updating the trust. Life changes. You get married, divorced, have kids, buy property, sell property. Your trust needs to reflect those changes. Review your trust every 3 to 5 years and update it as needed. Mistake 3. Not coordinating beneficiaries. Your retirement accounts, life insurance, and trust beneficiaries need to align. If your trust says your assets go to your kids, but your life insurance policy still lists your ex-spouse as the beneficiary, your ex-spouse gets the money. Beneficiary designations override your trust and will. Mistake 4. Trying to do it yourself. Estate planning is not a DIY project. Online templates miss nuances, state-specific laws, and tax implications. Hire a professional. Protect your family properly. Trusts for different wealth levels. You don't need to be a millionaire to benefit from a trust. If you own a home and have kids, you need a trust. It ensures your home passes to your kids without probate and protects them if you die unexpectedly. If you have a net worth over $100,000, you need a trust. Probate costs add up and privacy matters. If you have minor children, you definitely need a trust. It ensures assets are managed responsibly until your kids are old enough to handle them. If you have a net worth over $1 million, a trust is essential for tax planning and asset protection. The cost of setting up a trust is minimal compared to the cost of probate, estate taxes, and legal battles your family will face without one. For a comprehensive guide to building and protecting generational wealth, check out Money, Master the Game by Tony Robbins. It covers trusts, estate planning, and strategies for preserving wealth. Links in the description. Your next move if you don't have a trust, schedule a consultation with an estate planning attorney this month. Bring a list of your assets, your goals, and your family structure. They'll guide you through the process. If you already have a trust, review it. When was it last updated? Are all your assets funded into it? Are your beneficiaries current? Protecting your family's wealth isn't optional, it's a responsibility. A trust ensures that everything you've worked for goes exactly where you want it to go, without delay, without drama, and without the government taking more than necessary. That's wealth mode. If this video was helpful, please click the subscribe button and then like and share with your family and friends.